Hello everyone and welcome back to another video at Lawsisto. In today's video, we'll be discussing few terms and their differences. In this video, we'll be covering bailable and non-bailable offences, cognizable and non-cognizable offences, and compoundable and non-compoundable offences. The word bail is derived from a French verb which is bailer, which means to deliver or to give. In general sense, it means that to set a person free who is under arrest or under detention by asking that person to furnish security by competent authority for his appearance in the court on the fixed date. The Code of Criminal Procedure defines bail as bailable and non-bailable offences under Section 2A and is further defined and explained under sections 436 to 450. Bailable offences are considered to be less serious in nature, whereas non-bailable offences are considered to be more serious in nature. As a general rule, bailable offences are those in which the punishment is less than 3 years, but there are some exceptions to this rule. Whereas non-bailable offences, the quantum of punishment is high here and the extent of the punishment may lead up to life imprisonment. In bailable offences, bail can be claimed as a right and is granted by the police officer or by the court, and this can be traced under section 436 of the Code of Criminal Procedure. Whereas bail cannot be claimed as a right under non-bailable offences, and the court or the police officer has discretion of granting a bail, and before granting a bail, they are supposed to go to the facts and circumstances of each of the case. This can be traced under section 437 of the Code of Criminal Procedure. Examples for bailable offences are affray, cheating, bribery in elections. Examples for non-bailable offences are dowry death, murder, rape, voluntarily causing grievous hurt. All these classify as non-bailable offences. Cognizable offences are offences in which a police officer, in accordance with Schedule 1 of the Code of Criminal Procedure or any other law at that time being in force, can arrest a person without warrant. The Code of Criminal Procedure contains Schedule 1, which refers to all offences under the Indian Penal Code and puts them into cognizable and non-cognizable categories. Cognizable offences are serious in nature. The seriousness of the offence leads to maximum punishment. The first schedule of the Code of Criminal Procedure contains offences under the laws other than in the Indian Penal Code which are punishable with imprisonment for 3 years or more. Examples of cognizable offences are waging or attempting to wage a war, murder, dowry death, rape, kidnapping, criminal breach of trust, or unnatural offences. Section 154 of the Code of Criminal Procedure provides that under cognizable offences, the police officer has to receive an FIR, the First Information Report, relating to the cognizable offences. Non-cognizable offences are offences where the police officer has no authority to arrest without a warrant. Such offences are of minimal injury to the society. The aggrieved party is expected to file a complaint before the criminal proceedings start. Non-cognizable offences are more of a private wrong. Therefore, the initiative is taken by a citizen to prosecute the offender and to collect evidence. The police officer cannot arrest a person without warrant under non-cognizable offences and has no authority to investigate into such offences without the authority given by the judicial magistrate. Examples of non-cognizable offences are assault, forgery, or cheating. Let's understand briefly the differences between cognizable and non-cognizable offences. In cognizable offences, police can arrest without any warrant. In non-cognizable offences, police cannot arrest without any warrant. In cognizable offences, court's order is not required to start an investigation, whereas in non-cognizable offences, the court's order is required to start an investigation. Cognizable offences are more serious in nature when compared to non-cognizable offences. For a cognizable offence, one can file an FIR or complaint to the magistrate. Unlike in non-cognizable offences, one can only make a complaint to the magistrate. Compoundable offences are those offences for which the complainant, that is the person who has filed the complaint, or in simpler words the victim, enters into a compromise and agrees to drop the charges against the accused. Section 320 of the Criminal Code of Procedure looks at compounding offences. Compoundable offences are less serious criminal offences and are of two types mentioned in Section 320 of the Code of Criminal Procedure as follows. Court's permission is not required before compounding. When I say not required before compounding means that the permission of the court is not required before they settle the case or before they enter into a compromise. And examples of such offences are adultery, causing hurt, or defamation. Court's permission is required before compounding under these offences, which are criminal breach of trust, voluntarily causing grievous hurt, assault on a woman with the intention to outrage her modesty, dishonest misappropriation of property, amongst others. So for all of these acts and these offences, the court's permission is required before compounding or before agreeing into a settlement. Once an offence has been compounded, it shall have the same effect as if the accused has been acquitted of the charges. Non-compoundable offences. Now these are offences which cannot be compounded. They can only be quashed. The reason for this is because these offences is so serious and so grave and criminal in nature that the accused cannot be allowed to go scot-free. Here, in these cases, it's generally the state, that is the police, who has filed the case, and hence the question of entering into a compromise does not arise. All those offences which are not mentioned in the list of Section 320 of the Code of Criminal Procedure are non-compoundable offences. Under a non-compoundable offences, a private party as well as the society is affected by such offences. In non-compoundable offences, no compromise is allowed. Even the court does not have the authority or the power to compound such an offence. Full trial is held, which ends with an acquittal or the conviction of the offender based on the evidence given. Now let's briefly discuss the differences between compoundable and non-compoundable offences. Compoundable offences, the law allows a compromise. In non-compoundable offences, the law does not allow a compromise. The offences under compoundable offences are private in nature and the damage can be recovered by using a civil action. The offences in non-compoundable offences are public in nature. Once an offence is compounded lawfully, it has an effect of the acquittal of the accused. According to Section 320, subsection 2, certain offences require previous permission of the court before compounding these offences. For non-compoundable offences, offences have to be tried according to law. The court has no power to permit the compounding of an offence outside the limits of Section 320 of the Code of Criminal Procedure. I hope you understood the difference between compoundable and non-compoundable offences. With this, I would like to end the video. Please like, share and subscribe to our channel.